We have two cases on our 1:30 docket today. I am Judge Dunn. I will be presiding, and serving with me, I have the pleasure of serving with Senior Justice Alex Martinez and Senior Judge Jose Marquez. We will reconfigure between cases. So we will take a break after the first case. If lawyers are here for the second case, we will take a brief break and reconfigure our panel. Attorneys, have you received our oral argument instructions? Any questions? For our guests today, we do live stream and we are recording. So if there's anything sensitive in your oral arguments, please conduct them accordingly. We also would ask that all personal electronic devices be turned off. If they are on, they interfere with our recording devices. With that, counsel, we will call our first case Tallman versus On or One. You may continue when you're ready.
May it please the court, Christopher Forrest, registration number 23185, representing the appellant, Michael Tallman. There's a basic fundamental truth, which is the cornerstone of this case, which is that for reasons and under a policy which are obscure at this point, in 2011, Jefferson County destroyed the entire case file for this district court action. The only portion of the case file that was not destroyed was the Register of Actions. Now, ultimately, later on in the course of the litigation, we were able to recreate part of the case file and have it certified under CRS 131104. But that is the core foundation that should shape the standard of review and the level of analysis that this court engages in. And frankly, Mr. Ani in his briefs has tried to distance the analysis from the fact that the court record is destroyed, to the point where he even argues that it's irrelevant, which I think is an extraordinary statement. It's probably the single most relevant thing in this case. And I'll discuss later on in my oral argument the basis upon which the presumption of regularity should be applied to a destroyed and then partially reconstituted case file. The second, I think, most important strand of analysis in this case is that there's no dispute that Mr. Ani was held to a standard of clear and convincing evidence under Rule 60b-3 and the Goodman case in establishing that he had not been served with process back in 1996. And he was required to provide clear, strong, and satisfactory proof under the case law. And we don't believe that his filing by his lawyer, which was not verified and which was simply speculative as to events which had occurred over 20 years earlier, even remotely satisfies the burden of clear and convincing evidence. What happened in this case is unusual in that, relying on both the Goodman case from the Colorado Supreme Court and the Denman case from the Colorado Court of Appeals, Judge Arp simply said, I accept as clear and convincing evidence these unsworn arguments of counsel in a brief that Mr. Ani was not served. And really, the only statement in the brief, in the motion to vacate the judgment, was, had I been served back in 96, I would have defended this thing. That's a form of fallacious logic which really contains no substantive evidence whatsoever.
Well, Mr. Forrest, I think in the conclusion it asserts I wasn't served. I was never served in this case. That doesn't necessarily remedy your contention that it's unsworn, but I think the conclusion does make that statement.
He makes that statement, but he ends up ultimately by saying, I know I wasn't served because I would have defended. The problem is there's no specificity whatsoever, and this was not in a vacuum at this point, because we had provided both the motion for default judgment and the order to Mr. Ani and his counsel before. This is before they were ultimately certified by Judge Arp, which was later on in the process. But there was no dispute that this was the judgment and the order in the case. And there was specificity as to the date of service, the location of service in Honolulu, Hawaii, on July 16th, 1996. There was a certificate of mailing which had a specific street address in Honolulu for Mr. Ani. And in his evidence, so to speak, in the motion, he never once rebuts or provides any information as to where he was living. Was he living in Maine in 1996? Was he living in Hawaii in 1996? Absolutely no evidence, no specificity whatsoever. And again, it's a very high standard of proof. What's unusual is that at that point, Judge Arp sort of bounced the evidentiary ball to us and said, you must now produce the return of service. And if you don't produce the return of service, then you have failed to now establish by clear and convincing evidence that service occurred. And if you go to the omnibus final order, which is at page 333 through 336 of the record, and look at the final order that Judge Arp handed down, he really went through a four-step process, and I think one that was logically inconsistent and really doesn't follow the appropriate standard of review. First, he says remarkably, I assume that Judge Barnhill in 1996 had a valid, facially valid return of service in front of him that he relied upon when he entered judgment. He then says that there's no reasonable dispute that Mr. Ani has established by clear and convincing evidence that he was not served, which we obviously disagree with strongly. Third, he then, Judge Arp, completely rejects the presumption of regularity and says it's simply an appellate doctrine and I don't have to apply it because I'm the same court that entered the judgment, which really ignores the fact that you're talking about a judgment from 20 years ago and a record that is ancient.
Before you continue, isn't that actually somewhat inconsistent? Because it seems to me he did apply the presumption of regularity as to the fact that there was an affidavit in the file, that it facially showed valid service, and that the court made that finding. It seems as though he only fails to apply it to whether there was actually service. Is that right?
I think that's right. And then the final piece in that order, which I think is remarkable, is Judge Arp then certifies the order, the judgment, and the motion for default judgment as being part of the record reconstituted under 13-1-104, which statute says specifically that he's then required to give full force and effect to those pleadings within the record, because that's now the record. And in the next sentence in the order at page 336, he says these are completely irrelevant to my determination. And to me, that ignores the power of the statute. One of the critical pieces of the doctrine of the presumption of regularity is that if there is a piece missing from a file, and a lot of the cases have come out of Rule 11 advisements in criminal cases. If there is a record that demonstrates that a Rule 11 advisement was given, but the actual physical Rule 11 advisement has been lost, it's no longer in the file, it's still the obligation of the defendant by clear and convincing evidence to demonstrate that he wasn't properly advised under Rule 11. And the fact that that piece of paper is no longer in the file does not satisfy the burden to show that it wasn't regularly and properly entered at the time.
Mr. Forrest, I'm sorry, I want to back up really quick to the Goodman exception. Is it your contention that the Goodman exception only applies to facial irregularities on the return of service, such that the return of service is actually available for review? It appears that Judge Arp applied the Goodman exception just because it wasn't available at all.
I agree, and it's the Goodman exception, and if you drill down into Denham, which is the case in Goodman, the Court of Appeals case in Goodman, Denham versus Great Western Railroad, that's cited, that really is what Judge Arp grabbed onto as the core law that he applied. The interesting thing with both Goodman and Denham is neither of them are cases that deal with a lost or destroyed court file. In both instances, the fact of service and the physical return was in front of the court. And in Goodman, it's not even a question of the adequacy of service. The question in Goodman I mean, there was no question that there was service, and there was no question in Goodman that there was a return of service. The question in Goodman was, is service upon a employee of a registered agent sufficient service? So the question there has no bearing whatsoever on this issue. The presumption of regularity doesn't play in that case at all. The thing that's odd about the citation, which is I think really dicta in the Goodman case, because it didn't go to the core holding of Goodman, the citation to the Denman case, which arguably appears to create this bouncing ball presumption, Denman isn't a case in which Judge Criswell ever shifted the burden. It's not a bouncing ball presumption case. He literally had the physical return of service in front of him and said, I'm reading this thing and I think it's facially insufficient because it doesn't say X, Y, Z about who was served, when they were served, why they were served, how they were served. That is very, very different than a case like this in which you have binding decisions and binding recitations from the court in 1996, which Judge Arp is assuming are correct, that he had in front of him at that time a facially valid return of service. I think there's a completely different factual analysis and legal analysis that has to occur. It's also, I think, inappropriate at that point to bounce the ball back to us, and particularly given the weakness of Mr. Ani's attempt to satisfy his clear and convincing evidence standard, but to bounce the ball back to us and say, you guys go out and find this stuff. Because a lawyer's file is not a substitute for a court record. Let's assume for a minute that we had found some third-generation photocopy of a 1996 return of service. And we brought it back to the court and said, here it is, Judge Arp. What's to prevent Mr. Ani at that point of saying, maybe the sheriff's deputy who served it, he's dead. Maybe it wasn't me. I still deny it was that I was ever served. Where are we left with at that point? The problem is, because of the age of this case and the fact that Jefferson County destroyed the file, we're left at the risk that opportunistic attacks can be made on prior judgments where the record is...
It almost sounds as though you're saying it's an irrebuttable presumption. And I just want you to clarify whether you're saying that. I mean, isn't it true that even if we applied the presumption and that burden switching didn't apply so that it's clear and convincing evidence standard, presumably that could still be overcome by some of the things that you mentioned yourself earlier, by showing that he never lived in Hawaii, et cetera, et cetera.
I think that's fair, and I think ultimately what would have to happen is the court would have to say, all right, Mr. Ani, you have at least satisfied the threshold burden by clear and convincing evidence that you lived in Maine, or that you didn't live at the address that's on the return of service, or on the return, the certificate of mailing of the motion for default. Fine. If the ball then bounces to us, we engaged in extensive legal archaeology, literally, where we actually recreated 1996 billing records and established payments to the sheriff's department in Hawaii.
And the point is,
so we're really going to have two balls of evidence.
The point is that you would have to come up with some evidence beyond the state of the record.
Correct, but I also think that there's still the weight of what the recitations are in the file weighs in our favor. And the court ultimately would have to make a decision from an evidentiary basis as to whether there was sufficient evidence to say there was no service. Is this a harsh rule? It's a harsh rule on one side or the other because it's a 20-year-old judgment. And ultimately, at the end of the day, in this case, we're going to either get our judgment or Mr. Ani's not going to have to pay it. That's the problem with, frankly, courts inexplicably destroying their files with no notice to the parties. How are we ever to have anticipated that this would happen? And to then push the burden back on us to go out and cobble together whatever we could, and frankly, we did more than cobbling. We put together a pretty compelling group of evidence to demonstrate that a service had occurred, puts everybody in a position where how many files are out there that have been destroyed? Are there hundreds? Are there thousands? Are they all district court default judgments? Are they records related to bench trials? It allows the opportunity for somebody to come forward based on the way this case happened with the minimal amount of evidence and say, I was never served, and at that point, be
Excuse me, could I
absolved.
ask you a question?
Absolutely.
You said you had put together some archaeological evidence and mailing telephone records, mailing records. Is all of that in the record now?
Yes, it is, Your Honor.
And did Mr. Aoni, am I pronouncing it correctly, make any effort to rebut that?
No, he didn't. And as far the procedural posture of the case is, at the point we were able to discover some of this evidence, which took a lot of time and effort to put together, the judge had already initially ruled and said, you didn't produce the return of service, so I'm vacating the judgment. We were in the posture of a motion for reconsideration at that point, which frankly has put us to somewhat of a tactical disadvantage, because Mr. Aoni has now claimed that because it's a motion for reconsideration, there's a stricter standard of review. That's part of the whole problem with this, is the court said to us, go out and find these things. And then when we produced them, it was in the context of a motion for reconsideration.
So, Mr. Forrest, hypothetically, if we were to agree with you that there were some problems here, is the remedy a remand for an evidentiary hearing?
No, I don't believe it is. Mr. Aoni never asked for an evidentiary hearing at the commencement of this case. He had his opportunity to put on his evidence, and his evidence was nothing. His lawyers are experienced. They understand what an affidavit, what a properly verified complaint or motion looks like, and they chose not to provide that evidence. At this point, I think the case should be over. Our judgment should be, the order vacating the judgment should be reversed, and the pending motion to revive the judgment, which was denied strictly on the basis of lack of subject matter jurisdiction, should be nunc-pro-tunc granted, and the judgment should be renewed for another 20 years. Thank you.
Thank you, Mr. Forrest. Bailiff, will you add 32 seconds to the next argument? Thank you.
If it may please the court. This case presents two separate questions.
Counsel, could you introduce yourself?
I'm sorry. My name is Asan Wali. My bar registration number is 44010. I represent Mr. Richard Aoni in this matter. This case presents two distinct issues. The first being whether a court, in review of a motion to vacate under Rule 60b-3, is required to apply the presumption of regularity. And the second, whether the district court in this matter properly applied the standard under Rule 60b-3. The issue of the court destroying its file, just to begin with, is completely irrelevant to this matter. The reason it's irrelevant is because when a motion to vacate is filed under Rule 60b-3, it essentially says that the person filing the motion was not properly served. If a person has not been properly served, a court lacks jurisdiction over that person, and the judgment therein is void. The party that then, I guess, has the most incentive and the requirement under Colorado law to maintain evidence of service is the plaintiff. The plaintiff is required to maintain its own file and to keep that file on hand pursuant to their rules, pursuant to their obligations under the rules of professional conduct. And the reason they have to maintain evidence such as the return of service is because of situations not unlike this. Now, the rules of professional conduct do require attorneys to maintain in their own files documents that would be necessary if there were to be ongoing litigation. In this present case, we have a judgment that was obtained in 1996, and we have a garnishment that took place in 2016. This is a garnishment that was effectuated by a court order, a court decree. And for the appellant here to argue that the court's destruction of its file somehow prejudiced them is really a way to distract this court from what really is at issue here, is that they did not maintain their own file. And if they had maintained their own file, they could have presented the return of service, which appellee, before filing his motion to vacate, requested the return of service so that we may address what was in that return of service.
Does that make any difference if there is a court order which you agreed apparently was authentic, which the court accepted, and which states that all the rules and requirements of service were established, and then that gets us to the presumption of regularity? Why isn't that sufficient?
Well, the reason it's not sufficient is because the court had presumably a facially effective return of service before it back in 1996. We were deprived the opportunity of being able to review that return of service. We asked appellant's counsel for the return of service before we filed this. And so what happens is it puts us in a position where somebody who's had a judgment entered against them is in an impossible situation where they have to basically prove a negative. They have to sort of assume some facts about this return of service, about what it might have said, about where they were. And again, we have the passage of 20 years' time here. So it really puts them in an awkward situation. The standard
But
under...
Mr. Wiley, doesn't 60B3 in the Goodman case, that is the burden? The burden is on the party that didn't answer the complaint.
The burden is initially on the party that did not answer the complaint. That is absolutely correct. However, a Goodman also shifts the burden if the return of service does not demonstrate the essential facts to demonstrate adequacy of service. In the present case, that is exactly what we have here. We have a return of service that is missing or lost, which in this case is lost, and it doesn't therefore demonstrate the essential facts to demonstrate adequacy of service. And so therefore, the burden is then properly shifted to the appellant and to the plaintiff in this matter.
The problem is that Goodman doesn't involve this situation where the record is destroyed.
Well, Goodman doesn't, you're right that Goodman doesn't address that particular situation, but the record is never at issue in cases like this. And the reason it's not at issue is because the burden is not on the court to produce any evidence. The burden is always on the party that we are asserting did not serve the other party. And that's what Goodman addresses, and that's why the burden looks that way. The burden has to be on the party asserting that their service is proper, and and if they don't have the return of service for whatever reason, they need to provide other evidence by clear and convincing
in fact, the language in Goodman addresses, when the return of service does not show the, adequate requirements for service. You seem to just not think that the distinction between no return and a return which shows that the service was invalid is somehow it doesn't matter. But I'd like you to talk about that a little bit, because if the return shows that there was no valid service, that kind of makes sense as to why you shouldn't have a clear and convincing evidence. It's already been established, or the burden has switched, however you want to put it. I don't quite understand why the same is true when there's no return.
I believe the same is true for the following reason. Let's, for example, assume that there was no service in this matter at all, and that there never was a return of service, and the court summarily granted the motion to enter default judgment in this matter without a return of service. At that point, even if I filed...
But isn't that very different? I mean, your allegation seems to be that you were not actually served. I'm not quite understanding that there was an allegation that there was no return in the file, that the court failed to review the return. Those seem to be all the things that are part of regularity, actually. And the only part you challenge is the service. So it effectively says to me that the return is wrong.
The return, we wouldn't have the ability to know what the return says, because again, the return was not in the case file, and when we asked the appellants for the return before we filed our motion, they couldn't produce it. And so we were put at a disadvantage where we had just zero information about what exactly happened and how this was actually served. So,
But is your allegation more than, the return is invalid or the return is inadequate? Isn't your allegation your client was not served,
That
was
is
not actually served?
yes. The allegation is that my client, Mr. Richard Awney, was not actually served in this matter. And that's all that we made. It was an allegation under Rule 60b-3, which allows you to challenge a judgment if it is void. Now, if we were challenging the court's entry of the motion to enter a default judgment, we would have done it under a different standard, perhaps under Rule 60b-5. And that would have been more appropriate. And then, yes, perhaps the presumption of regularity would then apply, because we are asserting an error in the court's handing down of the order and the court's actual issuance of the order. That is the difference between when the presumption of regularity is applied and when the Goodman standard is applied. The presumption of regularity is applied when a challenger of a court order asserts that the court made an error. Not that the party didn't do something, not that the opposing party didn't do something, but when the court makes an error. So for example, if the court didn't follow its own procedures when reviewing a motion, for example, and that would be a situation. For example, if the court, in this particular instance, did not have a return of service before it, then we would have challenged the court's order, basically alleging that the court entered this default judgment without having a proper return of service before it. And that would have been the appropriate time to use the presumption of regularity and then put the burden squarely upon the appellee to provide clear and convincing evidence that.
I'm a little troubled by your notion that there's a choice between the presumption of regularity and the burden of proving by clear and convincing evidence. I mean, they are different things. One's a presumption, one's a burden. If they both applied, presumably the burden to show by clear and convincing evidence would overcome the presumption. I'm not sure why you suggest there's a choice of which doctrine to apply.
I don't believe it's a choice. I believe it's something that is appropriate when a certain type of motion is filed, I guess is what I'm trying to say. And so what I mean to say is that when a motion to vacate under 60B3 is filed, you would follow the procedures under Rule 60B3, which is set about by the Supreme Court of Colorado in Goodman, which is that, yes, initially there's this clear and convincing evidence burden upon the challenger, but if the affidavit of service does not recite the essential facts, then it shifts over to the other party. If we're saying that the court committed an error, then the court has to apply the presumption of regularity. So it's a factual and I guess a structural difference, right? It's who you're saying committed the error. If I'm saying the court committed the error, then you have the presumption of regularity. If I'm saying that I wasn't served by another party, then that party has the burden under Goodman if the return of service is inadequate. And in this particular instance, that is what the district court decided when we filed our motion to vacate the default judgment. So basically, the presumption of regularity and the cases that the appellant has filed here to I guess to push forward the idea that should have been applied are cases that are not from Colorado, and there's not a single case in Colorado that has a court applying the presumption of regularity to any motion to vacate whatsoever. They could not provide any of those cases, and instead had to go far afield to places like Kentucky, to the Ninth Circuit, to produce cases that were factually and legally distinct from this one to try to, I guess, convince this court that should have been the standard that was used. But if you look at the cases that the appellant has filed, for example, SEC versus Worthen from the Ninth Circuit, again, it was a case where the party filed a motion to vacate under a different standard and a different rule. The party in Worthen filed their motion under Federal Rule of Civil Procedure 60B5, which is a grounds for providing relief under an equitable basis. So not specifically that there was not service, not specifically that the judgment is void, but for a much broader set of reasons that can be proffered to vacate a judgment. And so the Federal Rule Procedure 60B5 has different procedures, and that's what happened in that case. And the court, for the most part, was unconvinced by Worthen, mostly because he had an opportunity in 1977 when he was released from jail to challenge the judgment against him, the permanent injunction by the SEC, and he didn't do so. And he waited until the 90s to actually levy any kind of challenge. And that was sort of the basis of the court's decision. Very different from what we have here. What we have here is a simple, money case involving allegedly some money that was owed from Mr. Ani to Mr. Tallman, a judgment in 1996, and then a 20-year period of just dormancy, where for reasons that go completely unexplained by the appellants, they did absolutely nothing. And then when they did absolutely nothing, they also, in the meantime, destroyed their file. And then after they destroyed their file, they decided to start a garnishment process through the court. So a very different scenario here. And then they also rely upon this other case, Park versus Raleigh. Now, Park versus Raleigh is a Kentucky case involving a criminal scheme, which allows a defendant to attack other convictions that are being used against him when he's being sentenced. And in Park v. Raleigh, again, it shifts the burden once the prosecutor proves that there is a conviction. It shifts the burden onto the defendant to prove that those convictions were somehow in error by the court. And again, that the defendant has to prove by clear and convincing evidence that there was some kind of error. Again, a case that is completely factually distinct from the one at present, involves Kentucky criminal law, and has really no bearing on this case at present. So in sort of wrapping this up, I think what the court needs to sort of understand is that there is a distinction when one is claiming that the court commits an error, and there is a distinction when someone says that they were not served by another party in a case. And that's what happened in this case. Mr. Awney was not served with process. He filed a motion.
Can I ask you a question about that?
Yes, Your Honor.
If we were to disagree with you and say that the presumption of regularity does apply, and that this matter should be remanded to the trial court, or at least had the question whether it should be remanded, what evidence would you have to show that your client was not served other than what you have already presented to the trial court? And that basically is a denial, I wasn't served.
Yeah, I mean, I suppose that's a difficult question, given that we don't know what their evidence is of how he was served. They're simply saying he was served. That's all they're saying. And even if you look at the district court, when the district court dispensed with their reconstituted record, district court said this is irrelevant because there isn't a time, a place, a person, there isn't anything whatsoever in the reconstituted record of the appellant that shows how service happened. So,
But the presumption of regularity assumes that you were properly served. And so the burden would be on you to show that you were not served. What evidence would you present to show that?
if we had to present evidence, we would have to present actual testimony from Mr. Awney about his whereabouts in Hawaii, or where he was, or what he was doing.
Why hasn't he already presented that evidence?
Well, because of the case in Goodman, Your Honor, we believe that it was our duty to simply address the lack of a return to service in that matter. And because Goodman provided for the burden shift, we believe that that would have been sufficient to shift the burden for them to come up with the evidence, since they're better situated, being the plaintiff, to present that evidence. So had they presented something saying, yes, no, we found the person who served Mr. Awney, that person indicates that he did it at this address,
Well, they apparently presented evidence of other kinds of records, some business records apparently indicating that Mr. Awney was in Hawaii.
And Mr. Awney very well did live in Hawaii, but the question is, was he served in Hawaii, and was he ever served while he was living there?
So you don't deny he was living in Hawaii at the time of this judgment?
I don't know if he was living at the time of the judgment, but I do know Mr. Awney at some point lived in Hawaii. That's correct.
Thank you.
That's all my time. Thank you.
Thank you, Mr. Lawley. Thank you, counsel, both, for your helpful arguments today. This case will stand submitted. An opinion will issue in due course. With that, we will take a recess and reconstitute our panel for our next case, so the case will stand in recess and the bailiff may so announce. Judge Freire on my left. Same rules apply. Any questions by council about our oral argument procedures? No questions? All right. If we've had any new guests join us, can you please turn off your digital personal electronic devices? They interfere with our recording devices. Council, when you're ready, you may begin.
Thank you, Your Honor. I'm John Purvis, and my registration number is 925, and I represent Carol Rademacher, who is the appellant in this case. Let me begin by saying that, as contrasted with the last court case that was before this court and I heard arguments in, this case involves no nuances, no subtleties, no new rules of law, no unsettled principles of law, none of that. It involves straightforward principles and rules of procedure involving the doctrine of summary judgment. That is contrasted with terms this court just heard in the last case about the presumption of regularity, for instance, is, at least to me, a completely foreign concept. It would drive me to the encyclopedias right away to see what's going on. But that's not true with respect to issues of the rules and regs and principles that govern summary judgment. All of us have gone to law school, all of us who've taken a bar exam have been exposed to those and know those basic general concepts at least. Those of us who have remained after those junctures in the litigation area in one way or another, as a judge or as a lawyer or both, are very familiar with those. We don't deal with them all that often because it is a very rare remedy, and the case law demonstrates that. It is a drastic remedy which is only to be used in the most clearest of cases, and that is an unusual circumstance. So we don't see those kinds of cases every day, but in every case that exists in terms of litigation, it lingers at least in the offstage. There always is a potential of that kind of motion coming.
As I read your briefs, it seems to me that from your perspective, the genuine issue of material fact here is related to damages, and that you're not contesting that at least the letter from Mr. Eddinghoff established negligent conduct or alleged negligent conduct, but that Ms. Rademacher did not know, she had no known injury until the appellate decision issued in September of 2015. Am I understanding your argument correctly?
Not exactly, Your Honor. We do contend that there is liability here on the part of Mr. Gressler for not doing his job properly in terms of research and the other things that we've alleged. We believe that there is fault involved at that level. Going beyond that, then, we believe that the damages are a result of failure of the trial court to pay attention to multiple areas of disputed fact, among them whether or not injury had occurred and when it occurred, whether or not Ms. Rademacher knew about the problem and when it should have been known, all of that. But those interweave with those being material issues of fact, which need to be resolved together with liability facts. I mean, is it, for instance, negligent? That's the key fact. Is it negligent for a lawyer to do or fail to do what Mr. Gressler did? We have, in the record reflects, an expert report from competent counsel that says, yes, that is negligent. But there is no doubt but what there will be opposing views on that expressed in the course of this case if it goes further. So that will be a major area of contested issues of material fact. So I would say that I hope I've helped to clarify by broadening what our position is. It is not the limited one that the court suggested.
Well, Mr. Purvis, let me follow up, because I think maybe the issue is not so much the contested liability, but whether the Eddinghoff letter or Eddinghoff letter was some notice at that point that there was potential, for accrual purposes, potential professional misconduct at that point.
There was some knowledge that Mr. Eddinghoff had done the wrong thing, that's for sure. There's an affidavit in the record which says Mr. Eddinghoff was not hired and did not look into and did not provide any counsel on the issue of whether there was negligence. And so there are competing issues of fact about that as well. It is certainly would be Mr. Eddinghoff's position that letter shows it. But our position is that there are various issues that are involved in that letter that need to be developed as matters of fact, including whether or not Mr. Eddinghoff was involved and provided counsel with respect to these issues, whether or not the information was conveyed to Ms. Rademacher, and if so, how, whether or not what he's talking about is prospective damage and prospective injury, or is in fact injury. So we say that the letter is really totally insufficient using summary judgment concepts to support a determination that there are no undisputed issues of fact, or that there are undisputed issues of fact with respect to a whole slew of things that show up in that letter. There is certainly the argument, as the court has indicated, that there was knowledge, or there should have been knowledge, but that's just an argument that would be met by us with counter arguments, again, of fact, which the court can't deal with in the summary judgment mode, is our position.
Counsel, I have a question, and it relates again to damages, because the letter is pretty clear. Mr. Eddinghoff stated in the letter that pointed out Mr. Greshler's shortcomings in the civil case and in the settlement agreement, and made an offer of settlement for the outstanding legal fees related to the civil action, and said that he would, going forward, be negotiating with the Becker's counsel to try to, I don't know, for lack of a better word, reach a deal before the appellate decision issued. So as I look at that, and there's clear case law that legal fees incurred to ameliorate damages are sufficient for claim accrual on the injury component. My question is there any evidence in the record to show that legal fees were actually incurred in connection with creating that letter?
I think the answer is no to that, Your Honor. And that, again, would be an issue of fact in that, in and of itself, and then why they were incurred and why, if any, they were paid, if any. All of those things remain at issue. And as I've said before, that and others could be resolved against us, but they can't be resolved just on the basis of a letter, which is unsupported by, most importantly, any of the evidentiary bases that the rule for summary judgment contemplates. That is an affidavit, deposition, or equivalent admissible evidence shown on the record to be that. And there isn't anything like that here.
Well, Mr.
Now,
Purvis, you do agree that summary judgment can be entered if there's on statute of limitations grounds. I mean, there are cases that enter summary judgment if statute of limitations have run.
That is correct, Your Honor. I certainly would not argue with that.
So the issue here is whether there was notice of both a cause of action and then the potential injury/damage portion, and when that happened. Is that your position?
Well, there is certainly a basis for argument as to what that letter signifies in terms of the knowledge that Ms. Rademacher had and when she should have had it. That is obviously fruitful ground for argument. But it is not an established fact. None of that. None of its contents are established facts. And they have to at least have been made, an effort had to be made to make them established facts by putting them into an affidavit form, putting them into a deposition form, putting them in other sworn statements, any of the kinds of things that Rule 56 contemplates in terms of admissible evidence that are to be considered. It is a drastic remedy, and for that reason, there are some strong but not complicated rules about what is supposed to happen to get to the point of summary judgment. All doubts are to be resolved against the person seeking summary judgment. All inferences are to be taken in favor of the persons not seeking summary judgment, and on and on. There are other principles equivalent to that, which simply make the argument here into argument. And there's plenty of room, as I said, for argument, but there is not plenty of room to say that Rule 56 has been complied with in terms of its procedural demands and the principles that I just referenced. So that's our position, Your Honor, fundamentally.
All right, Mr. Purvis, you have 4 minutes, 30 seconds if you'd like to reserve that for rebuttal.
I don't think I need to. Maybe I'll keep a minute or two. A couple of things I would like to touch on. One is that the focus of this case is so much on the summary judgment issue that it can obscure the fact that there are two important issues of cost involved in this case, which of course are moot if the case is remanded for further proceedings in the trial court. But those are issues which come up all the time in day-to-day litigation for lawyers in this state in terms of the collectability of fees for experts who are not designated as expert witnesses and fees for mediators who have been agreed upon by the two sides and predicated on an agreement, each would pay for half. So those are important things if the court needs to get to them. A third area I'd like to just mention to the court, and I did not argue this in the briefs because I don't think it bears on the issue of whether there was reversible error, but I think it does bear on important issues of systemic appearances of the justice system. And that is that what you have here is a judgment that's been issued in favor of a lawyer by the judicial system without any explanation as to why, and or effort to make that explanation. So it appears from the outside, can certainly appear, that is the obverse, that's the opposite of transparency, and that what in fact did happen here, if we could look through the transparent window, is that there was essentially an immunizing of a lawyer from liability for reasons unstated by the trial court. So with that, I conclude my remarks for the moment, if I may.
Thank you. You may.
May it please the court. My name is Margaret Parker, attorney number 40504, and with me at council table is appellee Ira Greschler. The core question for the court today is whether the trial court correctly granted summary judgment in favor of Mr. Greschler because the 2-year statute of limitations has run. And as the court is well aware, this is a legal malpractice case in which the plaintiff alleges that Mr. Greschler negligently represented her in settling an underlying civil claim and in the subsequent enforcement of that settlement. For today's purposes, the fatal problem with plaintiff's claims is that she in fact did know of her claims more than 2 years before she filed this lawsuit because her attorney, Mr. Eddinghoff, wrote a letter that outlines the allegations of negligence against Mr. Greschler and the injury that it had already caused her by that date. And he has already acknowledged in this lawsuit that he wrote it. This results in...
Ms. Parker, excuse me. Before the Court of Appeals ruled, what claim could have been brought?
So the question is Does your question go to what are the damages prior to the Court of Appeals decision?
Well, Ms.
Or-
Rademacher won below. They
Mhm.
won it in front of the jury. They won the directed verdict.
Mhm.
They went up on appeal. There was no decision reversing that. What claim could they have brought at that time?
So as of the date of that letter, May 1st, 2015, Mr. Eddinghoff identified in a letter to Mr. Greschler that he had been negligent in failing to foresee that this issue, public policy issue, could result in voiding the underlying settlement agreement. And therefore, he incurred all sorts of attorney's fees that Mr. Eddinghoff is now saying were negligently incurred. And that's approximately $90,000 in fees that Ms. Rademacher paid to Mr. Greschler in litigating the case, as well as some fees that she still owed him.
I understand that, but they
Mhm.
hadn't lost to that point. As
No.
of that point, they were
Mhm.
still victorious.
Right, but in order to determine whether there is a negligence and injury, which is all you need to know about in order to have a cause of action against somebody, that's all you need. You don't need to know the final outcome of the case to know that you've been harmed. Because the fact that you've negligently incurred attorney's fees that you should not have been incurred is a harm independent of the final result of the case.
What if they won?
What if they won? That still could have, there still could be a claim for negligence against Mr. Greschler on the allegations that they actually make here, and that Mr. Greschler should have foreseen that this would have been an issue and should have drafted around the issue, and therefore we would not have incurred all of the attorney's fees that we have incurred with Mr. Eddinghoff evaluating the underlying negligence, or in Mr. Greschler having to fight the issue on appeal. And I would point the court to the trio of cases that I think are squarely on point here. There's the Miller versus Byrne case, the Palisades case, and the Jacobson versus Shine case. In Jacobson and Palisades, they both support the notion that you don't need to wait for a final determination in a case to know that you've already been injured by an attorney's negligence. In Jacobson specifically says that. There, the client, the plaintiff, learned that her lawyer had negligently waived a marital interest, and then in a later bankruptcy, and she learned that in a later bankruptcy proceeding. And her claim accrued at the moment that her attorneys discovered this and had to litigate the issue in the federal bankruptcy court. She did not have to wait until years later to learn the 10th Circuit Court of Appeals is going to affirm that judgment. By definition, if her cause of action accrues on that date, as the court held it did, they didn't need to know whether the 10th Circuit was going to affirm or not affirm. The injury already occurred because she had to deal with the issue and incurred attorney's fees to deal with it. Similarly, in the Palisades case, the banking client learned that its attorney had failed to include a key contract term in a contract with another party. And the cause of action accrued on the date, or no later than the date, that the bank had hired an attorney to deal with that problem and to negotiate with the other party. The fact that later there was litigation over that, and the result of that litigation did not impact the cause of action accruing as soon as the bank incurred attorney's fees. The injury already happened because the negligence caused the bank to have to deal with this through the course of hiring another lawyer to work out the problem. Whether the bank won, the bank could have won on litigation and still said, you caused me all these problems. I would have had to litigate this issue for 3 years if you hadn't included that term. So it doesn't.
Let me ask you this: in Johnson and Palisades, they both lost below, and then they were trying to get a lawyer to mitigate the losses. Here, they won.
Palisade hadn't even been litigated by the time the cause of action accrued.
But they hired a lawyer to come in and deal with what they'd already determined was a negligent act. So here we have a victory, and then someone else challenging the victory.
I would respectfully disagree with that as to Palisades, because the bank knew the term was missing, but when it hired a lawyer and then the lawyer confirmed that the other side was going to try to enforce the contract as written, it was no later than that date that they were on notice that there was an injury and that there was negligence as a result, and that negligence caused that injury. Here, no later than the date that Mr. Eddinghoff researched and wrote a letter about what occurred in Mr. Greschler's representation, the plaintiff here is on notice of statements that Mr. Greschler has been negligent, and that he has caused her existing harm, and the letter expressly notes that the harm includes the over $90,000 in attorney's fees that she's already spent and were, according to Mr. Eddinghoff, negligently incurred.
So it's your position that she could have, before the Court of Appeals opinion came out, that she could have filed suit and proven both negligence and injury?
Yes, and the outcome of the final litigation, the final outcome would not have been, you would not have needed to know it at that point. In fact, it's pretty common in legal malpractice cases to file suit before the result of a final underlying matter, because you already know that the cause of action is accrued, but oftentimes the parties will agree to stay the litigation so that all of the damages can be known. Because it's pretty common, as here, to know that you've had some damages, and as soon as you know you have some damages, that's when the cause of action accrues, and that's the teaching of Palisades. So once you know you have some damages, then you can stay the lawsuit pending final completion of the underlying litigation, and then you have the universe of the case in front of you, and you can restart the case and litigate the full extent of damages.
Is there a difference between, I think you might have some damages, I think you might have been injured, and you actually have been injured?
Mm-hmm. Are you asking if there's a distinction?
Yes, for example, use this case. The letter says, we think you were negligent because there is this public policy, but the Court of Appeals hadn't yet ruled. So we think that there might be injury, but until the Court of Appeals rules, we don't know that there actually has been injury.
So I want to take us back to the statute that defines when a cause of action accrues, because that statute specifically says that a cause of action accrues on the date that both the injury and its cause are known or should have been known by the exercise of reasonable diligence. It's a question of whether the plaintiff is on notice of sufficient facts to charge her with knowledge that her attorney had been negligent. I don't think there's any question we have that here, and of sufficient facts that she has been injured by that negligence. Mr. Eddinghoff's letter puts her on notice of that information and gives a reasonable person notice that they need to investigate further. And that's what the statute requires and is consistent with the Miller case. And I think it would also help to discuss the Miller case, because that case is exactly on point here. The relevant facts of Miller have almost exactly the same facts as this case. There, the plaintiff's separate lawyer wrote a letter, just as here, to the attorney in question, alleging gross ineptitude in the underlying legal representation. The Miller court concluded that the fact of that letter itself demonstrated the plaintiffs knew or should have known of their injury as of the date of that letter, because it identified that the plaintiffs had already hired counsel to ameliorate the impact of that injury. So the letter contained the negligence and the alleged negligence and the fact of injury by virtue of having hired an attorney to deal with the fallout, so to speak.
Counsel, but doesn't Mr. Eddinghoff's affidavit state that he wasn't hired to ameliorate the injury, and aren't we required to accept that and to make all inferences in favor of Ms. Rademacher about that? Because he says, I was representing her in the divorce action. I think the letter itself clearly shows that he was attempting to ameliorate what he thought might be injury in the future, but I'm still having a problem with seeing what the actual injury is at that point before we know the Court of Appeals decision.
So I think there's multiple parts to your question, but Mr. Eddinghoff in his affidavit states, I was her divorce attorney in dealing with financial issues, but that does not obviate what he actually did. And in fact, we've also offered additional exhibits in our reply brief to summary judgment that backs up that what he actually did was he researched Mr. Greschler's underlying conduct, he listened to oral argument, came to conclusions, wrote a letter on behalf of the plaintiff to Mr. Greschler saying, you've caused my client damages, including your attorney's fees. Because of your injury, I want to negotiate down your existing pending fees that still need to be paid. And not only that, I am taking active steps to ameliorate the impact of what happened in oral argument a few weeks ago. Those steps include negotiating down Mr. Greshler's attorney's fees and taking active steps to try and resolve the underlying lawsuit quickly before the impending Court of Appeals decision.
And is there any evidence in the record to show that he actually charged for those fees and was paid for that letter, for those actions, or is that an inference that you're making?
I don't believe it is in the record, but I also don't believe that is necessary. If the court looks at Miller, and if the court looks at Palisades, and if the court looks at Jacobson, none of those cases rely on whether you see invoices from the attorney and whether they've been paid. The letter in Miller was self-evident and demonstrated that the plaintiff had hired an attorney to alleviate the impact of the underlying attorney's negligence. The Jacobson case, the facts there demonstrated that the plaintiff had an attorney litigating the bankruptcy court proceeding. And in the Palisades case, the Palisade opinion identified the fact that the attorney had been hired to deal with the missing contract term.
And what if Ms. Rademacher had filed a complaint, say, in June of 2015, what damages would she have alleged in her complaint at that time, or what injury would she have alleged?
The injuries precisely noted in the letter itself, that Mr. Greshler's attorney's fees, she would have sought disgorgement of those fees, and some combination of any fees that perhaps she had not paid yet. And then also, she would have alleged the fees that she has paid her new attorney or current attorney to actively mitigate the harm that Mr. Greshler has allegedly caused. Now, the fact that the Court of Appeals decision has not come down means that there's yet more potential injury that she may have. We don't know about that yet, but that's not what the law requires. Palisade says all you need to know is that you have some damages. Once you hit that point, you have a cause of action. You know of it, and you need to file your suit within 2 years.
But you would agree that those quote-unquote some damages have to be actual, they can't be speculative, right?
I agree that they don't have to be, they should not need to be, or they cannot be speculative, but I do think it's important to note something that the Broder case says in footnote 8, which is there is a difference between the term injury that is used in section 108 and damages. Because you cannot necessarily know the full extent of your damages at the time you file a lawsuit. That's one reason you have discovery.
Can I ask a different question? Mr. Purvis has raised questions and argues that there are genuine issues of material fact, and this happens to be a summary judgment. Can you state why there are no issues of fact?
Yes. So Ms. Rademacher, in her briefing in response to summary judgment, offered some exhibits to attempt to dispute the facts in this case. But what needs to be disputed is Mr. Eddinghoff, the fact of Mr. Eddinghoff's letter, and the notice that it gave plaintiff of her claims. None of the evidence that she offers disputes the fact that he wrote that letter or the statements that he made in that letter. All her evidence says is she offers some information about the underlying amount, the amount of the underlying judgment, which has no bearing on whether she knew or should have known of her claim. She also offers 2 affidavits saying that Mr. Eddinghoff was her divorce lawyer. That has no bearing on whether she knew or should have known of her claim because she was aware of sufficient facts that give rise to her claim, namely through Mr. Eddinghoff's letter. Now, she also offered some additional evidence in her motion for reconsideration, which is subject to a more stringent standard of review and, in fact, should not be considered at all post-summary judgment. But nevertheless, those exhibits do not provide any disputed fact that contradicts that Mr. Eddinghoff sent that letter and the notice that it gave her.
Thank you, Ms. Parker.
Thank you.
Mr. Purvis, you do have a little time remaining if you'd like any rebuttal.
Thank you, Your Honor. That would be even less than I have available. I just want to make the point that is well known to the court that there is a bright line distinction between something, a piece of purported evidence supporting summary judgment and it being the basis for a jury finding of fact. And so the fact that some of these cases say that this is a sufficient showing, doesn't mean it's a sufficient showing necessarily for summary judgment. That's all I have.
Thank you, Mr. Purvis. Thank you, both counsel, for your helpful arguments today. The case will stand submitted and an opinion will issue in due course. We have one case remaining on our 2:30 docket. Are counsel present for Basta v. Basta?
No, I'm good.
All right, counsel, we'll go ahead and proceed with Basta v. Basta next as soon as you're able to get settled. Counsel, while everyone's getting ready, do you have any questions about our oral argument procedures? All right, when you're ready, you may proceed.
Good afternoon. May it please the court. My name is Joseph Novak, attorney number 41904, and I represent the appellant, Surgeon Basta, in this matter. With the court's permission, I respectfully reserve 2 minutes for rebuttal. A litigant's use of perjured testimony to secure a verdict so corrupts the fact-finding process that a court may set aside the verdict if the perjured testimony impaired a party's ability to fairly and fully litigate a material issue in the case. That is the situation we are faced with here. The appellee, Tamara Basta, testified in 2 separate but related pieces of litigation. These 2 trials occurred barely 2 months apart and involved the same parties, Tamara Basta and Surgeon Basta. In the first case, which has been referred to as Basta 1, or the partition action, one of the primary issues was which party contributed $20,000 to facilitate the refinance of the Salida Street property, which put the loan at an 80% loan to value. Tamara testified that Surgeon Basta did not contribute any money to facilitate the refinance of the Salida Street property. Now, it is undisputed that Surgeon deposited $20,000 into the Elevation's bank account, which was used for the refinance. Tamara represented to the court in Basta 1 that Surgeon had paid her $20,000 as reimbursement for living expenses, rather than to be used for the refinance.
But didn't she ultimately use that money for purposes of refinancing?
She did use the money for
Okay.
refinancing.
So that $25,000 in the Elevation's account was used to refinance?
Yes, absolutely. And the record is clear, though, and cited in detail in the briefs, that Tamara testified that Surgeon wrote her a $20,000 check for living on my expenses during his unemployment, and therefore it was not related to facilitate the refinance of the property. Now, Surgeon denied owing her any money in Basta 1 and claimed that the $20,000 contribution was for the refinance. Now, by testifying in this manner, Tamara was able to convince the court in Basta 1 that she should be awarded an additional $20,000 in the equity because it was her money used to facilitate the refinance, and Mr. Basta had not contributed anything towards the refinance.
Well, if he paid her for living expenses, wasn't it in fact her money?
Yes, but the point is, in Basta 2, she never represented that he was paying her back for living expenses. What she represented consistently...
She was never asked that question, though, was she?
She wasn't asked that direct question, but time and time again, anytime the conversation came around the $20,000 payment, the first thing she said was the money was deposited for the purposes of the repayment. When you say for purposes of the of the refinance, that's different than saying the money was deposited as payback for living expenses.
Why would that not be consistent with the idea that she intended to use that money for refinancing?
Because she expressly stated to the court in Basta 2 that this money was deposited for purposes of refinance. And what she said in Basta 1 was this money was deposited as reimbursement for living expenses,
For the purposes of refinancing.
which she then used for the refinance, but it wasn't deposited for the purposes of the refinance. It was deposited for purposes of reimbursing her for living expenses. That's the representation she consistently made to the Basta 1 court.
Counsel, I have a question about the standard of review, because it seems to me that's kind of the guiding principle here. And you didn't put a standard of review in your opening brief, but the answer brief gave an abuse of discretion standard of review. Do you agree or disagree that that's the standard?
I do agree that that is the standard for review. Now, on July 25th, 2016, the parties went to the trial in the county court proceeding. And in this trial, Tamara was countersuing Surjan, claiming that he had improperly withdrawn $8,000 from the same Elevations account. And she took the position there that although he had deposited the money into the Elevations account, it was deposited to facilitate the refinance, which is in direct contradiction to her testimony in Basta 1. Now, it was advantageous to her to testify in Basta 2 in this manner because the court was trying to determine if Surjan had ever deposited personal funds into the Elevation account. If the money was not to be used for the refinance, then the court would likely have found that Surjan was entitled to withdraw the money.
Even if it was for the purpose of paying her back for living expenses?
Well, it's important.
If she had been asked that question, would the court still have found he was entitled to take that back?
Yes, and the reason being that Surjan has denied that he owed her any money for living expenses. And so that's a disputed issue in the county court proceeding as to whether or not this money was to be used for paying back some alleged living expenses or was just to go into the account and directly out of the account for the refinance. And so if she had said, well, this was paying me back, that opens up a new issue in the county court proceeding. Because then Mr. Basta will deny that he owed her any money, and then that money is at issue, whether or not that $20,000 was his money or her money. And so in order to avoid that issue, she simply said, oh yes, he deposited the money, but that was for purposes of the refinance. It went in and it went out. That's the representation she was making. Now in Basta 2, Tamara testified as follows, quote, question, Ms. Basta, do you recall at the time of opening the account in 2011, Mr. Basta put a deposit in of $11,000? Do you recall in 2012 that Mr. Basta deposited $20,000 into the joint Elevations account? Answer, quote, I said I believe for the purpose of refinancing the house, yes. She then responded to the court's follow-up question in Basta 2 that, quote, the account was opened for purpose to refinance the house. Now, why would she testify in one proceeding that he did not contribute to the refinance and testify in the other proceeding that he did contribute to the refinance? Well, we know she benefited from her testimony in Basta 1. The partition order gives her credit for the $20,000 she claimed was a repayment of money owed for expenses. She's given credit for that $20,000 on the page 9 of the partition order. In Basta 2, Tamara was accusing Mr. Basta of improperly withdrawing $8,000 from the account. So the court needed to determine whether or not he had ever contributed money. And so she could not testify that he had deposited the $20,000 as repayment for living expenses because he denies that. And then it opens up the issue as to whether or not this was his money or her money. So by claiming that the money just went in the account and went out the account for purposes of refinance, she could present the image that Surjan never deposited any funds into the account. Now, interestingly enough, Tamara does not deny the contradictory nature of these statements necessarily. She claims she was confused. Tamara is a research assistant with a background of a double major in biology and physiology. She has a master's degree in human molecular genetics and a PhD in developmental biology with an accent on human brain development and degeneration. She has been employed with the University of Colorado since 2002. That's 14 years before these trials occurred. She is, no doubt, a smart, educated, and sophisticated woman. The BOSTA 1 trial was on May 22nd, and the BOSTA 2 trial was on July 25th, barely 2 months apart. The main issue in the BOSTA 1 trial was the parties' respective contributions into the home, and she denied that he contributed anything to the 2012 refinance. Yet in BOSTA 2, she consistently responded that the deposit was for the purposes of refinancing. Tamara's reliance on Exhibit L in her response brief has absolutely no bearing on the issues in this appeal. That exhibit is just a self-serving, demonstrative exhibit that she used, and it was created for the BOSTA 1 trial. The fact that her own exhibit supports her testimony at the BOSTA 1 trial, that's to be expected. If there's any importance to Exhibit L, it's the fact that the $20,000 was important enough to be included on her exhibit and for her to prepare and to testify about that contribution. Yet then Tamara asked this court to believe that she suddenly became confused, did not understand what the court or what surgeon's attorney or what her own attorney was asking her about in BOSTA 2. One thing that is missing from Tamara's brief is any other conversations or issues related to other $20,000 contributions or deposits. There were no other $20,000 contributions or deposits. There was one, and that was made into the elevations account. And she was very clear in BOSTA 2 in stating that that money was deposited for and used for the refinance.
And she was very clear in the partition proceeding that it was given to her as reimbursement.
Correct.
How is the question Judge Frere asked was, what is the standard of review? And that's abuse of discretion. I think you concede that.
Correct.
Okay, if the court has discretion to, okay, I'm presented with this information now, isn't it within the court's discretion to decide what do I do with this information?
Yes, and that's one of the issues that's raised in the briefing, is whether the trial court erred by disregarding the testimony from the related proceeding.
Well, how do we know the court disregarded it?
Well, the trial court's order denying the motion to amend expressly states, quote, "It is the district court record and its own findings upon which this court relies," which says that during that order, she says that the testimony was confusing. Therefore, she relies on the trial court's record from BOSTA 1. What I submit to this court is that under Rule 60, B2, she has to at least consider the testimony from both proceedings and make a determination as to whether or not they're consistent or contradictory to each other.
Doesn't paragraph 5 say she considered the county court testimony?
It says she considered it, but then just in looking at the issues, but then in making her final determination, she disregarded it.
Well, she says she considered the full context in which Ms. Basta's county court testimony was rendered.
And finds that the issues were confusing.
And finds
If I recall
that they
correctly.
weren't that her statements in 2 didn't substantively conflict with statements in 1. So if she considered the statements in 2, I mean, to reach that determination, she had to consider testimony in both, right?
Well, but I understand what you're saying, but what the order says is that I considered all of this, but at the end of the day, I'm throwing my hands up, and it's the district court record and its own findings upon which I'm going to rely in entering this order. And what I submit is that you need to at least evaluate and compare the statements. And if you find them to be confusing, then as the judge, you have the authority to request a hearing on the topic or request more evidence. And in this case, it was just, I throw my hands up and I'm going to stick with the record that I have before me. And I submit that under Rule 60, that's improper, as the new evidence should at least be considered in making the determination. And I'll cite to Aspen Skiing Company versus Pier for that. In that case, the court did find that there was no perjury, but it did make a statement that was relevant. First, it stated that the court's reasoning was that the that it was a case of varied observations and recollections. The court was considering two different affidavits that were attached to the Rule 60 motion. And so it compared the two affidavits to the testimony that was presented at trial. The court said that if Aspen Skiing had presented evidence that the party allegedly committing perjury, quote, had admitted to some other person that he had fabricated his version of the accident, or had persuaded or attempted to persuade other witnesses, the court would have found perjury. Now, in this case, we're not comparing Tamara's testimony to other witnesses. Rather, we're using her own statements. Both of these statements were intended to persuade the court of her respective version of the facts and to gain an advantage in both of these proceedings. And again, I go back to some of the statements from her. In Basta 2, at one point, Tamara states, quote, I think that he put some money for refinancing the house. Notice how she does not say that I put money for refinancing the house, which is what she says in Basta 1. She also states, quote, the account was opened for purpose to refinance the house, and that, quote, all the money went for refinancing. Tamara's brief cites additional testimony, which further cites Surgeon's position. Quote, question, and the $20,000 that was put in, that was utilized for the refinance at the time, correct? Answer, correct. Question, it didn't sit there for any length of time. Answer, no. No, it was. Question, immediately used. Answer, immediately used for refinancing. For down payment, actually. The court, all of it? The witness. All of it. I mean that and the money that I had put into that account, yes. Perjury is committed when a witness testifies under oath to materially false statements in an official proceeding, such as trial, under circumstances where the witness does not believe the statement to be true. Tamara committed perjury here. She testified in Basta 1 that Surgeon contributed no money to the refinance. And she testified in Basta 2 that Surgeon contributed $20,000 to the refinance. And she reemphasized this on several occasions during the proceeding. This court can conclude that the testimony was intentional based on the circumstances. It's her own words that are contradictory, as opposed to competing witnesses' testimony. She had something to gain in each proceeding by testifying the way she did. Accordingly, Mr. Surgeon Basta respectfully requests that this court remand the case and order the trial court to credit Mr. Basta with an additional $20,000 in equity and an award of his legal fees and costs.
Thank you.
Thank you.
Good afternoon. I'm Andrew Spiegel, registration number 18305. I represent the appellee, Ms. Boston, in this matter. We're not here today to relitigate what transpired in the trial court. We're here to review whether the trial court applied the proper legal standards and evaluated the appropriate evidence before it. To start with, it's important in this situation to remember what's in the record that was presented to the trial court, which Judge Sierra reflects in her order denying the motion to alter, amend the judgment. It's just testimony from a separate proceeding. It happened to involve the same parties, and it happened to overlap in a factual way, but it did not involve the same legal determinations. There's nothing in the record to indicate what Ms. Basta's intent was in testifying in the trial court or in the district court. The appellant's making a number of assumptions about that, but they're not supported by the record. There's no questioning of her. For example, why is this answer to this question different than your testimony in the district court? How do you explain that? It's never touched. And as detailed in the brief, the questions came up long after direct, cross, redirect, and only upon the judge's questions trying to seek some clarification. And it wasn't about whether the $20,000 should be allocated to Mr. Basta or Ms. Basta. It was about the parties' bank accounts. So it wasn't even on the same issue. Now, the parties seem to agree that by a case law that everybody should be following here is the Aspen skiing case from 1991, Supreme Court case, Sharma versus V. Hill, 1998, and Antolovich versus Brown in 2007. And the standard that the trial court was to apply was whether there was willful fabrication of testimony in the district court, not the county court, but in the district court. So it just stands to reason, as was done in each of the three cases, the trial court looks at its record of the proceeding before it to determine whether the alleged misconduct, in this case perjury, presented by affidavits or some other evidence, amounted to perjury in the first proceeding, in this case. And there's no evidence of that. There's no evidence in the record, no suggestion, even no argument in the appellant's brief that there was willful fabrication, which is, under Aspen skiing, the necessary finding. And that finding has to be based on, as articulated in Sharma versus V. Hill, clear, strong, and satisfactory proof. And we don't have that. The trial court concluded that what we have after reviewing the testimony in the county court is confusing questions and answers. That based on the trial court's hearing of the partition case and observing the witnesses as they testify and going through the exhibits used in the partition case, such as Exhibit L, and the fact that the focus there was on determining where did this $20,000 come from, what was it for, and how was it used. Those were central to the determinations of the district court in the partition action. So Exhibit L is relevant because it's in part what Judge Sierra had in front of her for concluding, as she did in the partition action, that the $20,000 was reimbursement for living expenses, and that Ms. Bosda then used it to contribute to a refinance. And there were two refinances in 2012, which makes the questioning in the county court even more confusing, because one happened very early in 2012, and then one happened later. And as pointed out in the brief, Ms. Bosda was faced with a compound question. And this court doesn't have to decide which part of that question she was answering in order to affirm the trial court. This court just needs to look at, did Judge Sierra, on the record before her, see any evidence of willful fabrication on a material issue in the partition action? And her order denying the motion goes right through the analysis without ever mentioning the cases, but goes right through the analysis and concludes that it was just confusing. And as pointed out in the Aspen case, and I think it's also cited in Antolovich versus Brown, I think quoting Aspen skiing, that witnesses oftentimes get confused, and there may be discrepancies in their testimony. And that's what the fact finder is supposed to determine. But that doesn't amount to misconduct without a showing of willful fabrication on a clear, strong, and satisfactory level of proof. And in these three cases, which had more in terms of direct evidence than what's being presented by the record here, perjury was not found. And as this court, I'm sure, is aware, you look at what the judge did in each of those cases, even though Aspen was a jury trial and so was Antolovich versus Brown, but Sharma v. Hill was a bench trial it went back to what transpired in the case and looking at the evidence presented by the movement and compared it to what they knew and concluded from the trial before them in order to, in all three cases, conclude that it didn't rise to the level of perjury.
There was an argument by Mr. Novak that the trial court did not consider the county court testimony.
Well, as we point out in our brief, Your Honor, in interpreting and reading the judge's ruling, her style seems to be to essentially state the issue, state the parties' respective positions, and then proceed to analyze it. And in her ruling, several places she does mention that she had to be reviewing the county court. She mentions in paragraph 3 what the plaintiff is using to support their motion, and discusses the testimony that Ms. Basta addressed in the county court, and states that Mr. Basta's impression is that Ms. Basta provided conflicting testimony about the nature of his bank accounts, or bank deposits, excuse me. So clearly, just from that, you can see that the district court is analyzing what needs to be analyzed in terms of the issue. And then, as pointed out already, in paragraph 5, the trial court says, taking into consideration the full context in which Ms. Basta's county court testimony was rendered and the manner in which the question was asked, the court disagrees with Mr. Basta that Ms. Basta's testimony substantively conflicted with the testimony rendered in the district court. So it seems pretty clear from just this paragraph that she's reviewing what she had before her. There was no evidentiary hearing conducted here. None was asked for. All she had was the transcripts. And by way of rebuttal, Ms. Basta, in submitting a verified response to the motion, disputed that and stated under oath in her affidavit that she had no intent to mislead the court, that she was simply confused by the questions being asked. So if this court were to find an abuse of discretion on these facts, it would open up the floodgates of parties that want to challenge using 60B2 discrepancies that oftentimes occurs, the cases point out, in trials, which is not the standard. The standard is willful fabrication. And we don't come close to that in this case, or have a record that even suggests it. Therefore, the trial court's analysis here and application of the cases interpreting 60B2 is proper. Its determination of whether the testimony amounted to perjury is supported by the record, that it isn't, and that within the standard of abuse of discretion, clearly deciding that on the record before it, that it was just simply conflicting but not misconduct is certainly reasonable and one of the outcomes that the court could choose. And therefore, this court should affirm the trial court in all respects. And thank you.
Thank you, Mr. Sweetcall. Thank you both, counsel, for your very helpful arguments today. You ran out of rebuttal time in your direct. The case will stand submitted and opinion will issue in due course, and that concludes our docket for today. The court will be in recess and the bailiff may announce.